Good evening, everyone. I'm Robert Dunham. I am the director of the Death Penalty Policy Project, and I'd like to welcome you to our webinar today featuring former Lackawanna County District Attorney and Pennsylvania Attorney General Ernie Preate. Ernie argued the most important death penalty case in Pennsylvania in the United States Supreme Court, upholding the constitutionality of capital punishment. And he's gone through a long journey since then, which we're going to talk about. Before we get there, though, I want to thank Pennsylvanians Against the Death Penalty for hosting this webinar and give a shout out to our co-sponsors, Witness to Innocence and Amnesty International. By way of a little bit of background, as I said, I'm the director of the Death Penalty Policy Project. I represented Pennsylvania death row inmates for 25 years before becoming executive director of the Death Penalty Information Center. And now I am a special counsel at the law firm Phillips Black that does pro bono death penalty representation, and I run the Death Penalty Policy Project. Ernie, let's start, I guess, pretty much at the beginning. How did you go from being the foremost advocate in Pennsylvania for capital punishment to now being a vigorous opponent? Can you sort of take us through that and how you were as a prosecutor and now how you are as a private citizen who is concerned about the administration of justice?
That's a very good question, and it's one I've answered before to other people and other venues. But in short, a couple of things changed for me. One is that after I argued Blystone, and I remember my history as a district attorney was that I had prosecuted. I was homicide specialist. I prosecuted 19 homicides. I sought the death penalty in 7, got it in 5, mostly serial killers. And then when I became Attorney General, the statute that under which I had prosecuted cases and obtained the death penalty was challenged in the Blystone case out of Western Pennsylvania. And as Attorney General, I'm obligated to argue the constitutionality of Pennsylvania statutes in courts of law. And so I did argue it in the United States Supreme Court. And we won, as you pointed out, a 5-4 decision against the mandatoryless challenge that the statute mandatorily got juries to vote all the time for death penalties. What happened is that as Attorney General, I became more aware of what was happening around the 67 counties in the state. I knew what was happening in my county, in Lackawanna, Scranton, but when I found out that there was this disparity in what was being sought by prosecutors in one county was not being sought by prosecutors in another. There was a level of sophistication on the defense in some counties and none in others. There was a superlative number of prosecutors in Pennsylvania, Roger King, for example, in Philadelphia, who were really good at getting death penalties. And there were other prosecutors that didn't know what they were doing. And so it just struck me as this is a chaotic way to try to find whether somebody is innocent or guilty of a murder and then get the death penalty on them. It was just helter-skelter. It wasn't any organization, wasn't any administration, wasn't any structure. And so when I got involved with the Third Circuit, looking at and I think you were on that panel, Rob. I'm not sure if you were, but studying the death penalty and how to get lawyers to be trained and how to get a better a fair judgment by a jury. And it became apparent that there was this lack of funding for defendants, lack of training for defense lawyers, and a serious lack of training for prosecutors. I wound up writing a book on how to prosecute a death penalty case, which I have here, and and then I was teaching that all over the United States, not just in Pennsylvania. Pennsylvania prosecutors. Uh, but I found it wasn't the same. Was this the same factual situation was replicated in other states? You had some prosecutors that were charging death penalty cases every single time, and it was disturbing to me because, in my view, that's the last thing that you want to do as a prosecutor is to say, I want the jury to put this person to death. I mean, you have to do it, but it never it was dawned on me that there was just a total disorganization in the process of prosecuting and defending. The funding wasn't there, so I was therefore feeling that maybe we shouldn't have the death penalty after all. It's because we just can't get the promise of due process that the Constitution said we should have in these proceedings, and effective assistance of counsel, um, for a
And
variety of constitutional issues. So
I was going to say,
said that got me to the point where I questioned it. The second the ground is the moral ground, and that this is important too, because a couple of years after I argued Blystone, I argued Planned Parenthood versus Casey, a very famous case in the annals of the history of American jurisprudence, and that was the abortion case that tested Pennsylvania's abortion statute. And Governor Casey asked me to argue it. He was a Democrat. He asked me as a Republican to argue it because he said, look, you've had some experience down there at the court, and you know the issue, and you're pro-life. So I argued it. And that churned out a whole decision that undercut Roe and Planned Parenthood versus Casey became the law of the land from until 2 years ago. The point being is that I believed in the protection of human life from inception to death. Well, how do you square, in my mind, logically, I was grappling this with, how do you square saying it's okay to put somebody to death under circumstances you're not sure that the person is in fact guilty or should deserve the death penalty, and yet you're allowing people to allow abortion in America? And it just was so overwhelming. Both the practical and the moral came together, and that's when I decided I don't think this is fixable. I don't think it's logical. I don't think it's philosophically defensible. And so I came to the position in the late 90s, that was my position. Was I just don't see pursuing the death penalty in America. And as I said, I think you and I talked about it. There's like only 27 states now that have the death penalty.
right.
That tells you that there's a lot of states out there that think it's wrong for a variety of reasons. But the fact is that as a prosecutor, I sought it in rare instances, but I don't think that anymore that it is possible to have a fair prosecution, fair death penalty defense in America.
And one of the things that's interesting, and you and I were talking about this off camera the other day, is the constitutional issue that came up in Scott Blystone's case was whether Pennsylvania's death penalty statute was mandatory. And the way we got to that is because in his case, there was an aggravating circumstance. That's a statutory reason to impose the death penalty, but the jury didn't find any mitigating evidence. And Pennsylvania's statute is what's called a weighing statute. You're supposed to weigh aggravation and mitigation. And the jury had a question. And the question the jury asked was, if we don't find any mitigating evidence, any mitigating circumstances, do we have to impose the death penalty? And so your argument was, and it's one that the United States Supreme Court agreed with, and frankly, I think they decided correctly, was that because no one is requiring the jury to reject mitigating evidence, so it's not mandatory. But I later became counsel for Scott Blystone. And when I was representing Scott, what I realized was the jury wasn't asking whether it could return a mercy verdict. It had actually decided that there were things about the crime that didn't deserve the death penalty. And they didn't know. And the lawyer had been practicing law less than a year. And he'd been practicing law 3.5 months. He had no homicide trials before. He had only a couple trials at all. And he didn't know that what they were really saying was that there was mitigating factors about the nature of the crime itself. And now the case goes all the way up to the United States Supreme Court, and nobody realizes that this inexperienced lawyer hadn't conducted any kind of mitigation investigation into the case and hadn't presented any case for life. And we end up overturning Scott Blystone's death penalty because of ineffective assistance of counsel, and he ends up getting a life sentence. And now here we are, we're 40 years later, 35, 40 years later, and we're seeing the same lack of good representation in Pennsylvania cases.
Well, that's exactly what I was trying to get at when you asked me the question. There are some lawyers that are going to be able to do it, to take advantage of the resources that are available in Philadelphia, but they're not available in Elk County, and that's wrong. You can't say, oh, you have a better chance of winning in Philadelphia than you do in Elk County. That shouldn't be the determinant of the geographic disposition of the case, but it often is. The lawyer isn't trained, the prosecutor isn't trained, and then you get these cases where the prosecutor says, "Oh, here's all the evidence," but they didn't go and check all the other police agencies to get facts. They didn't go and do a thorough search of evidence of DNA. I mean, it just.
I remember you telling a story, and can you tell the folks who are listening to the webinar the story about the case that you're most proud of?
Yes. I one of the cases that I had in the 80s was that the head of the school board in Scranton was shot and killed in a parking lot on his way to a meeting, and so they arrested the police arrested a person, and they directed the investigation toward that individual to the not checking anybody else's story. We go through in police questioning, grand jury questioning, trial preparation, and then and when I get into the trial, 3/4 of the way into the trial, when I'm getting my critical witnesses in this death penalty case, a state trooper takes the stand, and the defense attorney shows him a report that he had, a private report, not a public in file report. It was just a piece of paper that he'd written some notes on. And I looked at it. The judge says, "Mr. Preate, take a look at this." I looked at it with the chief investigators and said, "Oh my God." So I asked for a recess. I talked to the witnesses because the witnesses had revealed that there was another person with more motive than the person I had on trial. And in fact, the person that was testifying against the defendant was the person who had the most motive to kill the victim. And that the widow knew about it and withheld that information. There's a lot more I'm not going into here, but I said that was it. I went. My father was a lawyer, and so I talked to him that night, and I said, "Dad, I don't think that this is a viable prosecution anymore." And I depended on his advice, and he says, "What do you feel?" I said, "I feel like I got an innocent man. I got the wrong guy here." He says, "Well, that's what you tell the jury." And so nobody ever heard of that before. That a prosecutor in a major case, and I was well known by that time, 1985, and
this was a death penalty case.
This is a death penalty case, and I went before the jury the next day, and the judge said, "Judge, I'm withdrawing the charges based upon the information that I've been able to receive in the last 24 hours." that indicates that I may be prosecuting the wrong man here. And the courtroom erupted. Um, and they, of course, the defendant himself came over to and thanked me. But everybody said, you're going to lose the election. You're going to lose. You're going to get blown away. You did. The chief of police called me and said, you're going to pay for this. He was, person in the other party. And I said, look, I have to call it the way I see it. I'm not going before a jury and asking you to believe somebody that in my heart I know is lying. I'm not doing that. I'm sorry. But
and then actually, after you did that and the charges were dismissed,
the charges were dismissed.
You were up for election again.
Yeah, I won by more votes the third time than I did the second or the first.
And
so that tells me that what people wanted to hear, and this is what I kind of get it run across the prosecutors, is you can make the tough decision. If you do the right thing, the people respect that. If you're out to get a conviction for the sake of conviction and put it up on the wall and say, look how many death penalties I got, that's not what a prosecutor is all about. What a prosecutor is about is to do justice and to be fair in doing it. And so I always tried that. That wasn't the first case I did. We did a couple other murder cases too, where we found that the police had brought and overcharged. All right, brought first-degree murder. It should be third-degree or voluntary. I mean, this you got to make those decisions as prosecutor, and under your oath and under your ethical duty. So I think that when I say to people, they say, well, yeah, I had so many cases, and I said that's the one I'm proudest of, because I did the right thing. And people say it was going to cost me, but it didn't.
And that raises two issues that I want to get into. Maybe we can take them one at a time. The first is the question of what will taking a principled position on the death penalty. How will that affect people who are running for office? There are, we've heard through history that if you take a position against the death penalty, that's political poison. You're going to be done. But my experience and taking a look at the polls suggests that you know it from the perspective of a prosecutor, but from the perspective of a state legislator, voters are not going to hold it against somebody if they have a principled reason for the position they're taking on capital punishment. So if they believe in life and they don't think the government should take life, voters respect that, whether they agree with them on the death penalty or not. And if they hypothetically or theoretically support the death penalty, but they believe that the system is administered in a way that is arbitrary or discriminatory or racist, or we just can't get it right, voters respect that too, don't they?
I think that's the voters today are more educated and more discerning, and they're not. That's one issue in multiple issues in a campaign. But you have to articulate it properly. If you just say, "Oh, I'm against it," or "I'm for it all the time," people say, "You going to use good judgment as a prosecutor?" I don't. My kid gets up there for a burglary. You're going to want to put him in jail for 20 years. They want you to be able to discern facts, as you did in Blythestone. You went and found that there were facts in the crime itself that evolved right out of the factual situation of the prosecution that the jury could easily have found mitigating, and that maybe the mitigating outweighed the aggravating. And if there was one person that believed that, then you can't get the death penalty in Pennsylvania. There's one person. So that was the beauty of the Pennsylvania statute, and that's why it's still the law of the land. And I think it's probably one of the most important death penalty statutes in America right now. If anybody wants to figure out how to do it, that's what you use, the Pennsylvania model. But as I said, I don't go there anymore.
And that's also the thing about, people are the folks who are administering this process, right? And you were talking about there are prosecutors Not every prosecutor is going to, when they discover this exculpatory evidence, not every prosecutor is going to stop in the middle of the trial and admit that the state isn't doing it right. So there are some prosecutors, regrettably, who will proceed even though they have evidence that the person didn't do it.
Happens all too frequently, and we're still finding in the last Supreme Court term where prosecutors withheld exculpatory evidence. Wait a minute, this is 2025. This isn't 1970s. This is 50 years ago. We all know that you have to disclose that when it's requested, Brady material, and they still, or you're having to suppress a questionable statement. I don't want to let them see that. It might raise questions. It might take them down a road that might lead to innocence. I just think that there's too much of that um, um, in the system, and it's not correct. We had 50 years to teach it, to instruct on it, to learn by it, to see the results of cases on appeal by it, and we're still doing it the wrong way. Well, then if you can, then maybe those states that say we're not having a death penalty got it right.
And the folks, in Pennsylvania, when I was executive director of the Death Penalty Information Center, we launched a prosecutorial accountability project because it was really surprising how many cases seemed to be overturned because of prosecutorial misconduct. And so we wanted to get an idea of, is this just something that we're noticing because we're looking for it, or how often does it happen? And we've now found more than 700 death sentences that have been overturned because of prosecutorial misconduct. 50 of them in Pennsylvania, and 13 different counties have had cases overturned because prosecutors in Pennsylvania withheld exculpatory evidence.
That data that you've articulated now is compelling. I sensed it 20 years ago, Rob. I sensed it. I was seeing it in my own prosecutorial friends. And I just said, let's not happen. We've had enough time to change. The Supreme Court slapped us around a number of times. And we still didn't learn to do it right. So I've taken the position, if you can't do it right, then we're not doing it at all.
Now, one of the things Pennsylvania, sadly, is known for, and you alluded to it earlier, you were on the joint Supreme Court Third Circuit Task Force that ended up recommending the creation of the Resource Center, which is how I stepped into capital cases. And back then in 1990, you talked about there were problems of a systemic nature, the failure to provide meaningful counsel at all stages of a capital case. And what was it that you saw that led you to think about that at that time? And then I'll tell you a little bit afterwards about how nothing's changed. But what was it that you saw?
Well, the court was in control of the defense, and you only get so much money to hire experts. They're budgeted, and I don't know that there's capital training now. You can train them all you want, but if they don't know how to do it, they haven't been trained as litigators. And law school does not train you as a litigator, folks. All right, teaches a great way to argue appellate cases, but doesn't teach you how to be a litigator. Totally different. Totally different. And so if you don't know how to litigate and litigate ethically, and to exercise your judgment with the police as they're going through the process. And by the way, one of the things that I did, which was different than a lot of DAs, I went to the scene of the crime while the bodies were still there. I didn't want anybody to tell me about it. I want to see it with my own eyes. So I had a picture of it when I'm doing it before the jury. And it makes it a lot easier if you've been there and see the sights and sounds and smells. But the point being Did not enough prosecutors like that. You pointed out those damning statistics. I sensed them then. There were cases then. When I first took office as Attorney General, I had one of them presented to me, the Smith case, a very famous case in which a man was accused of murdering two people at the shore, a teacher, I believe it was, and he was prosecuted by the Office of Attorney General, by the prior Attorney General's office, Roy Zimmerman. Nice, very good prosecutor, but he had to delegate it to one of his assistants. And the assistant said with the state police that there was no exculpatory evidence. He was looking for a comb with sand in it and whatever, for a reason it was going to be exculpatory. So Bill Kostopoulos, the great defense lawyer, great lawyer, and down in the mid-state, was on appeal, and he was demanding that there be a search made to determine whether or not this exculpatory information existed. So between the time I was elected and the time I took office in January, I had Bob Gracie, who was chairman of my appeals division, and said, "Give me." I said, "Give me the box. Bring it up to the office." And so he brought it up. We looked at it, and there's the comb that Bill Kostopoulos said existed, and the prosecution of the Attorney General's office said didn't exist. I immediately called him. I called Bill. I said, you got to take this to the Supremes. I said, because we just found what you're looking for. And of course, the Supremes threw out the conviction on the grounds that there was double jeopardy. Not only that you don't get a retrial, but you're barred from prosecuting this case any further. That's the office of Attorney General. You'd think they were the smartest of them, but they didn't. I'm learning firsthand. I'm seeing that stuff. And so you've articulated the numbers, and I think that they're probably correct. I don't see any reason why to doubt those numbers.
Yeah, and for folks who aren't familiar with Jay Smith's case,
Jay Smith, that's what it was.
There were issues about where the murder occurred, and he was saying it was in New Jersey at the shore, and there's sand. There should be sand in the bodies. There should be sand in this comb, and the prosecution said nothing like that exists. And it turns out, of course, that it did. And Jay Smith sort of leads us into one of the other issues that I think resonates both for people who are interested in protecting innocent life and for people who are interested in the fairness of the process overall, and that's the question of innocence. We have 13 people who have been sentenced to death in Pennsylvania and then exonerated. Which is a staggering number. And there are others who are innocent, who were sentenced to death, who died on death row before their cases could go all the way through the courts. When we do things as people of good faith, we make mistakes. And there's just no way you can take that human factor out of the death penalty as a whole. No matter what happens, somewhere along the line, one of us or more of us are going to make mistakes and they're not going to be corrected. That means that there's always a risk that an innocent person is going to be killed. But when you combine that with the lack of resources and training, that's been the case with the defense lawyers, and the same problems that you recognized as prosecutor. What is it? Can you have any faith that we are going to always be getting it right?
I don't think you can get it right all the time, and I don't want to take the mistake. I don't want to. I don't think we should risk at this stage, having had all this experience, that we can allow one mistake. One mistake is one too many. I'm sorry, but that's my belief. You can't say, "Oh, well, we killed an innocent man." No, we shouldn't kill him. That's the point.
We're talking about 13 in Pennsylvania, and now if we take a look at the national figures, we now have 200 people who have been exonerated after being wrongfully convicted and sentenced to death since the United States Supreme Court's ruling in 1972 that threw out all existing death penalty statutes and had the country started all over again. But that's one person exonerated, wrongfully convicted, wrongfully sentenced to death and exonerated for every 8 people who've been executed. And that's, I mean, I think if planes crashed with that frequency, we'd be doing something about it.
Right. I think that that juries, and I could be wrong about this, Rob, and maybe some of the folks out in the audience knows this, senses this, but juries today are a lot more reluctant to give the death penalty because they sense that there's the chance that this guy might be innocent. They don't want it on their conscience, so they're not giving the death penalty. I could be wrong, but
I think that's right. And what we do know, we can't always get into the heads of everybody in the process. But when we look at the numbers, we see that not only are states one by one moving away from the death penalty altogether. We moved from 38 states with capital punishment. Now we're down to 27. But counties are pursuing it less frequently. And part of that is because over the course of years, there have been institutional capital defenders who've gotten involved and have raised some of the level of defense. So, it's less likely that the case will be won, but also it's not just that lawyers are better. I think public support for capital punishment has dropped from 80% in the 1990s when you ask the question, do you support or oppose the death penalty, to 53% now. And for the first time last year, the Gallup poll found that a majority of Americans thought the death penalty was unfairly imposed. And 60%, when they were asked the question, the policy question, what's the more appropriate punishment for murder, said alternatives to the death penalty, not the death penalty, is a better choice.
Well, where I stand on alternatives to the death penalty. I'm working with Senator Sharif Street on parole for lifers, which leads people to call me a bleeding heart. No, because there are people who are lifers that were wrongfully imprisoned too, that pled guilty to escape the death penalty, and maybe they're innocent of that. I mean, we've got a system that isn't working, that's being run by people perhaps of goodwill, but lack of don't have the training or the ethical standards to do it, and the commitment of the system to pay for the defense of a case. Oh my goodness! Wait a minute. That's more than the budget of the county with some of these smaller counties, so there's all those considerations that are taken into account. That is irrational. That's not what due process is all about. That's not what the constitutional protections are all about. Not dependent on money, not dependent on human error. No, you got to get it perfect, and if you don't get it. So I've come to the conclusion that you have to articulate it. And I mean, some of the people in the Pennsylvanians United Against Death Penalty, it's a great group, but they say, Ernie, what are you doing trying to get lifers out now? I said, because I know them. I visited 27 institutions. I communicated with 10,000 inmates over the 20 years until COVID. I met these lifers. I met some of the death penalty people. Some of them I put in jail. They still, oh yes, I met one of my guys. I met him out at Green. So, but the point being that you got to have it. You have to have, when the system is dependent upon imperfect people, and we all are imperfect. You shouldn't be playing with human life.
And we were talking the other day about arbitrariness. And there are a lot of things that go into that. 27 states have the death penalty, 23 don't. 67 counties in Pennsylvania all have a death penalty statute. that doesn't mean that 67 counties are using the death penalty. And prosecutors have discretion, and they exercise discretion differently. Can we talk about some of those things, and why you think that makes the system so arbitrary that it's not sustainable?
I think that's the right word. It's arbitrary because if the crime is in Elk County, I'm using Elk, or Potter in the mid state, way up there, or Tioga, uh, and it's in Philadelphia because you got the resources down there where the death penalty is going to be sought. The same crime, serial killer, for example, up in there may not be prosecuted in the northern tier. And that's because they don't have the money, the training, the resources. Well, if they do go forward, the chances are that somebody is, because it's a rural county, a conservative county, is going to be they're going to impose the death penalty. I don't like those odds.
Mhm.
I don't think that's the way you have this most important decision on life or death being determined by geography, by imperfect people.
And now
Um,
today in Philadelphia, there's a district attorney who is not pursuing the death penalty, but in Washington County, there are 10 death penalty cases that are pending. And that's, a little bit imbalanced, I would say.
well, that seems to me to be where I think the Supreme Court of the United States, maybe now I'm 84 going on 85. Maybe in your lifetime, Rob, it's going to happen. Maybe in somebody else's, but the Supreme Court of the United States is going to say it's in point of fact, it can't deliver a fair a verdict, a constitutionally fair verdict, and so we're going to abolish it. The the data, the research may very well be so clear that the court's going to say, "I'm sorry, but we're not going to be able to uphold the death penalty as a punishment in America." And there are other countries that have already said they're not going to have that as a part of their punitive system. So I think the death penalty is going to be overturned by the United States Supreme Court as unconstitutional as applied.
Yeah.
As applied.
And
That's the hope, I think, because I think getting legislators in Pennsylvania or some like Alabama or Georgia ain't going to happen. Okay, I mean, they're bragging themselves how many people they put to death. I detest that. I fought in a war. I fought in Vietnam. I was a Marine in combat. I wasn't in the rear. I saw people getting killed. I had to put bodies in baskets and ship them home. You don't want to do that. You want to make sure that everything is done to protect human life at all costs. So I'm in the position that um, I was a voice in the wilderness. Maybe 20 years ago, maybe there was a couple of people like you, uh, Jules Epstein, Professor Rudowski, uh, that were in the forefront. Angus Love, um, but I think the tide's turning. It's going to be guys like you or women that make the argument to the Supreme Court to say that you cannot assure us as a nation that this is a fair proceeding to obtain a just result. Not happening. Too many times it's not, and the numbers are compelling that you put forward. Compelling.
And for folks who are watching, one of the things, we talked about the differences in counties, and you can pursue the death penalty under the law, um, but but maybe you will and maybe you won't. That the single most important factor in deciding whether something was going to be a capital case wasn't what you did, it was what side of the county line it happened on, and what the prosecutors uh, theory of running his or her office was. So that brings us into the question of prosecutorial discretion. So even assuming that people had equal resources, we're seeing vast differences in the way the death penalty cases are pursued from one place to another. And so in some places, you have things that look like what we would call second-degree murder, accomplice murder, someone who has a, who is still criminally liable and should go to jail, but is not sufficiently morally culpable to justify pursuing the death penalty. But they get overcharged, and the case perceives goes forward as a death penalty case. And then in other counties, something that something like that doesn't even get a first-degree murder charge. So how do we account for the role of discretion in prosecutorial practices when it comes to whether the death penalty is a policy that should come or go?
Well, there is no, the district attorney has the discretion to charge or not to charge based upon his evaluation of the evidence under the statute. And that is a solemn responsibility. It's the biggest responsibility you have. So if you don't have ethical standards, if you're politically motivated, if you've got all the money in the world to prosecute the case, you might make the wrong decision. You might overcharge. You might be arbitrary in bringing the charges, trying to squeeze it in to the various categories. But that brings me to the same circle we started. Is it's arbitrary. That's not the way the system should work. Oh, it's arbitrary. You're in a money county or a poor county, a rural county or an urban county. It shouldn't be the determinative factor. It should be the facts themselves. And you got to make a judgment as a prosecutor in your discretion as to whether or not you want to go for the death penalty. And I think that a lot of prosecutors today, hopefully, are taking that mantle and saying, I'll be very, very careful if I ever ask for the death penalty. There are some out there, and some are getting elected. Mm-hmm. All right. Krasner got elected. DA Krasner gets elected for saying I'm opposed to it. All right, but let's say, that's an urban Democrat, Allegheny County. Try it a county in the mid-state. Well, you might be surprised. There might be a lot of people in that rural county that just philosophically, morally, religiously are opposed to the death penalty. So I think that the arbitrary factor is that the one major problem in the discretion. It's just too much arbitrariness. There's no guidelines. How do you have guidelines for use of discretion? It's ethics. It's your ethical standards that really accounts for that. But I just don't think we could ever do that. I'm almost 85 years old. I've been prosecuting since 1970, or one way or another. Now I'm a defense attorney, and scaring the hell out of people because they know I know where the bodies are buried.
Speaking of scaring the hell out of people, there's an issue that's really overlooked a lot in states that have the death penalty, where police during the course of an investigation or prosecutors during the course of negotiations threaten witnesses or threaten defendants with the death penalty. And there are a range of ethical issues about whether you can or should do that. But one of the new studies that I'm working on is taking a look at how the presence of these death threats, because that's really what it is, creates a risk of wrongful convictions in cases that don't end up with a death penalty. So, a witness gets threatened with the death penalty if they don't cooperate, and they end up telling the police officer what they think the police officer wants them to say. or they get squeezed, if you will, by prosecutors, and then they take a plea deal and they testify falsely against somebody else. It turns out that in the last 6 years, there have been 70 cases of exonerations in those kinds of circumstances.
Well, again, you got as a district attorney, you got to make that you can't let that happen.
Mhm.
You just can't. You just can't be bought by somebody that's a quote unquote rat, uh, and have them run the decision making of the prosecution. You've got to evaluate that very carefully. And today it seems to me that with all the cameras we have and all the cell phones and all electronic devices, listing devices, viewing outside convenience stores, there's a lot of stuff that we didn't have in the 70s and 80s. In those days, you had to rely on co-conspirators. Now you got the video camera, you've got the dashboard camera, you got the police officer wearing the camera on his lapel. A lot of prosecutors, if they really, or defense attorneys, what does your lapel camera say? Oh, all of a sudden I can't find it. Really? All right. Those are things that they have to be trained to do now. May not be so much reliant on as they were decades ago on the co-conspirator that flipped. Now you have the video camera, and what happened to the evidence on the video camera? Think about that. That to me is, and I've seen it where finally after 8 months I get the video, and it totally exonerates my defendant. Why did you wait so long?
Yeah, yeah.
You knew you had it. I had a motion to compel after motion to compel.
So I think what it all boils down to is that even in a fair and ethical system, we make mistakes, but we can't guarantee. Not only can't we guarantee that it's a fair and ethical system, experience tells us that it's not.
It is not. Exactly right. And that's why I think the Supreme Court's going to come down. You've got enough evidence now, statistical evidence, and the court does rely on statistical evidence. It started with the Brandeis brief almost 100 years ago. The court does rely on statistics.
Yeah, for folks who are listening who are not lawyers, Louis Brandeis was a brilliant lawyer before he was a brilliant judge.
Right.
And in one famous case, he wrote very little but had a giant footnote in which he presented all the sociological facts. And it's now gone into legal lore as the Brandeis brief. Powerful. Let the facts speak for themselves.
As I said, I'm using a lot of legal terms that you and I are familiar with. Maybe the audience isn't, but they're second nature to us, Rob.
Yeah.
And they're second nature to the Supremes too. I know several of the justices. I can tell you that even if you're conservative, you're still going to look at those facts. They're compelling facts. And so, in a nation, in a jurisprudence that's flooded with federalism now, that's states' rights. But the court's going to see, well, what are you doing in your state? And what are you doing in the other state? They can still compare states. They can still compare counties within the state. They can still look at factors. So there's just, as I said, there's too much arbitrariness, and you folks have got the right idea, is to pursue your legislators and say, look, we shouldn't go forward with this anymore. You should be advocating for the abolishment of the death penalty, because you just can't get it right. We've had 50 years to try to get it right, and we can't get it right.
And in those 50 years, what's so interesting is when the United States Supreme Court struck down all death penalty statutes in 1972 in Furman versus Georgia, they talked about it being arbitrary, like being struck by lightning
Right.
is arbitrary. And they talked about the need to have kind of heightened procedural safeguards. Uh, well, what we've seen in the 50 years is that the safeguards have been more honored in their breach than actually having made a significant difference. Um, the court said that you have to, you have to look at these cases a whole lot closer because it's a matter of life and death, and death is different. Um,
Yes.
and yet, the United States, and this is my sort of preaching, the U.S. Supreme Court requires 4 votes to agree to hear a case and 5 votes for a stay of execution to keep the defendant alive to hear a case. We had just 2 weeks ago somebody executed on a 5-4 vote. There were 4 votes that would have granted review, and that wasn't enough to stop the execution from happening.
Well, is that the function of the legislative mandate that the court is obliged to follow? Is it because we have an anti-terrorism effective death penalty law and PCRA statutes that say, oh, you've got to be at the time limits are compelling. So you waived it if you waited too long. You didn't raise it properly, articulately. I mean, that's one of the things that really got to me too was when I was working on that legislation back in the 90s as the chairman of the co-chairman of the National Attorneys General Association. I was chair of the Criminal Law Committee, 50 states. Ernie Preate, Bob Del Tufo, Republican Democrat. But he was in New Jersey, I was in Pennsylvania. And we were looking at this stuff, and what we were coming up with is the same thing that we're talking about now, the arbitrariness. We're talking about the fact that we didn't have a way to get the case from an assertion of innocence to be heard in the court. Well, my philosophy was, look, this is death. Death is different. If the guy has a complaint of I'm innocent, hear it. Yeah, it may take a little bit longer, but hear it. Don't try to. We spend more time arguing over the waivers and time delays and inarticulate assertion of a claim than we do than having the claim litigated substantively. Please, this is death. Let them have. And by the other thing is, we have a statute in Pennsylvania that says, "Oh, you're entitled to DNA." Why? Well, wait. I used DNA in 1985. I got a guy from Berkeley. There was only 2 people in the world that did DNA. Then I brought him in because I didn't want Harold Cain, the greatest defense attorney in Philadelphia, throwing his. They say you could have had DNA done. It exists. You could have had DNA done and analyze this guy to see if it was murder or just choking to death. So I had it done. It showed nothing. I mean, because the esophagus was soaked in formaldehyde. But I did it. I did it because I saw that as my responsibility to show that I was aggressive in getting the DNA analysis. But the statute that we have today, which was meant to help people on appeal, say, can you give me a DNA sample so I can see if I'm the right guy here? Okay, I don't think I'm the right guy, and the DNA sample will show it. And we can't get it. We litigate the right to get a DNA test done. It should be de rigueur. It should be automatic. And this is 2025, not 1995.
And you and I were talking about this the other day, the case in Florida with Tommy Ziegler. Tommy Ziegler's been on death row for 50 years, and for 30 years he's been trying to get DNA testing. And the state attorney, that they don't call them district attorneys there, they call them state attorneys. The county state attorney was opposing DNA, and finally, a a state attorney was elected who thought, why would we not want to find out what the truth is? And so agreed to DNA testing. And then the state attorney general went to the Florida Supreme Court to try to block the DNA testing from taking place. It
Wasn't Pam
turned out,
Bondi, was it?
no, no,
It wasn't Pam. Right.
no, it wasn't Pam. It was her immediate successor.
Well, yeah, I know it tougher.
But what happened was uh, the testing went through and the results came back just about a month and a half ago. And they support the defense case that it is
50 years
physically
later.
impossible that Tommy Ziegler committed this offense, and he's been on death row for 50 years. You know, in Japan, they were talking about the world's longest serving death row prisoner is exonerated after 48 years. This is 50 years. Tommy Ziegler is innocent. He still hasn't gotten off of death row, but they have filed a motion to have him declared innocent. But he's been there 50 years trying just to get his case heard in court.
Well, so what we're seeing is the legislature allowing for the utilization of this new test, a DNA test, and then the courts, under pressure from the prosecutors, kind of shrinking back from giving the full panoply of rights under the statute. Maybe it's the legislature intended, and maybe you got to go back. Folks, you want to go back into the DNA statute and see if you can get a better DNA statute in the legislature here. Okay, it's done routinely now. DNA is done routinely. If you don't, if I want a case in Dauphin County, a drug case. They said that my man was using a heroin, and they said he had a lot of heroin needles in the waistband next to his bed. The problem was that he had moved out of the bedroom, went to live with his girlfriend, and his buddy moved into his bedroom and was using the needles and were his. But the prosecution went ahead and said they're his needles. And guess what I said? Where on the ship does the slip a piece of paper, Mr. Chief Prosecutor? Why didn't you check for DNA on the needle? And the jury is looking like Perry Mason just spoke. Not guilty. Not guilty. And the guy had served time for murder. And it was in the record that he had served time for murder, was pardoned and got out. And now they were prosecuting him. So anyway, even then, it doesn't have to be in a death penalty context, but it can be in a drug case.
Why? This is the thing that has always confused me, because I'm always looking for people being good people making mistakes, not bad people trying to obstruct justice.
Mm-hmm.
Why would a prosecutor want to oppose DNA testing in a death penalty case?
There isn't any reason. There should be none. It's so easy. It's not expensive anymore. It's not $10,000. You know, we're keeping records of everybody in the prisons with their DNA. I mean, we're solving crimes by the prison records of DNA. I mean, really, it should be, if you're a good prosecutor, you say, I want the DNA. I want to sure I got the right guy here. It depends on the person in the system, but it should be that the legislature or the court could say, Brady requires that you turn over exculpatory evidence upon demand, upon request. The court can just as easily say, you now have to turn over DNA when requested. That ends the subject.
Yeah.
Mr. Supreme Court, you come down with that ruling that the case is over. Okay, everybody's going to get DNA, and it's not that hard to do. We're doing it in paternity cases, for God's sake.
Now, I think that the DNA tells us a lot about what's wrong with the system.
It does.
And what is scary and very few people know this, the DNA has been present in only about 12 to 15% of the death row exonerations. In 85% of the cases, the exonerations have not involved DNA at all. I've represented 4 death row prisoners. I've been on the defense teams for 4 death row prisoners in Pennsylvania who've been exonerated. And the case that I think taught me the most about the problems with evidence in death penalty cases was a gentleman by the name of Nick Yaris, who was convicted and sentenced to death in Delaware County, suburban Philadelphia. And in Nick's case, there were 4 eyewitnesses who described somebody who Nick looked like as having been present outside of a store in the I think it was the Christiana Mall, from which a woman was kidnapped and raped and murdered. And they had blood from, from the crime scene. They had blood on gloves that they said were the killer's gloves. Uh, and, and they had semen evidence and physical evidence from underneath the fingernails. There was a county prison guard who said that that Nick had confessed to him, and there was another prisoner who was awaiting trial who said that Nick had confessed to him as well. So you had and the blood type on the gloves was Nick's blood type. So this is a pre-DNA case. Nick's only defense was, well, I didn't do it. I wasn't there. I had a fight with my mom and I stormed out of the house and I went down to the corner store and I was at the grocery store. And so, you're a really good prosecutor. You know, you know what the prosecutor says here. He says, well, wait a second. His mom has every reason to support his story, and the grocer has got no reason to know what day that was that he was there. And we have 4 eyewitnesses, and we have a matching blood type, and we have 2 people that he confessed to. When we got the DNA testing done in the case, the DNA samples all came back and they were the same person, and they weren't Nick. And what it told me was that all the other evidence in the case that looked like an overwhelming case for guilt, all the other evidence was wrong. And there is no reason to believe that that same kind of getting it wrong doesn't happen in cases in which DNA isn't ultimately available.
Mm-hmm.
So, to me, the lesson from DNA is we can exonerate people. It's also, we got to be really, really careful about the evidence that we use. And when there isn't physical evidence that directly ties somebody to a crime, then I think using the death penalty in those cases is really risky.
Well, it sounds like that the district attorney was impressed with the volume of evidence, but under those circumstances, by the way, was this at a time when they didn't have cameras in convenience stores?
They certainly didn't have a camera in that convenience store.
And that can, okay, all right. Well, the point being is, it's so easy to do.
Yeah.
Test the glove. All right, just go ahead and have it done.
Yeah.
I mean, that would have been my. I want to be sure I got these guys. You're all telling me that looks like him. That's a big sign right there. Looks like it's not him. All right. But I don't like prison confessions.
Yeah.
There are lots of reasons for prison confessions by guards and by other inmates, obviously. But one of the things that you'd have to do is just a prosecutor just in every case do it. In every case do it. I don't care if it's a drug case or it's a whatever. Do it. It's $400. Basically, and they can come back with, or if it's a little bit more sophisticated, it might be a little bit more money. But I think that it's important that prosecutors utilize all those tools initially to make sure that they have the right guy, and don't wait for the defense attorney to be asking for it. And I think that that's why Supreme Court or somebody's got some authorities got to say, in every case, upon request, you got to do a DNA. It's like a fingerprint. We're doing fingerprints all the time. Why can't we do DNA all the time?
Yeah. And before we get to questions that people are putting in the in the Q&A, there's one other area that I wanted to talk about. As chief law enforcement officer in the state, the Attorney General, one of the primary concerns you have is public safety. And in your experience, did you see any evidence, and I'll tell you some data a little bit later, but did you see any evidence that having the death penalty made the public safer?
No. It's to say that it's a deterrent, it just doesn't understand human nature. There are people that they want to commit murder. They're not going to say that, oh, am I going to get the death penalty or going to life in prison? They don't do those kinds of analysis, that evaluations prior to doing the act. They're just emotionally or determined to rob, to kill, to rape, and it doesn't matter whether they're going to get the death penalty or not. They hope to get away with it, but I don't see it as the deterrence at all. All it is, in many instances, as you pointed out, and I'm going to say this again, the death penalty is brought so that they can do two things. One, death qualify a jury so they get a better prosecutor pool. Or two, use the death penalty as a bargaining chip to take the case. Well, you drop the death penalty, you plead guilty to a life in prison. That's what's going on with the death penalty. It's being misused. Rob, it's being misused. You tell me you didn't find in all your analysis that they would bring a death penalty case just to get death qualify a jury? I mean,
and in fact, you know, and we hadn't gotten into the whole issue of jury selection, but there was a famous videotape in Philadelphia. It's called the McMahon tape because a homicide prosecutor named Jack McMahon was called in to provide a training to young district attorneys, young assistant district attorneys in Philadelphia. And Jack was not given a whole lot of advance notice, so he kind of winged it when he was doing the training, and the training was on tape. And what's on that tape is astonishing. One of the things that he realized he realized when he said it was wrong, so he tried to back off from it, was we charge in these Philadelphia cases, we charge this aggravating circumstance called grave risk of death. Because when a crime occurs outside, you place other people at risk, and you know what? It gets us this death qualified jury. It gets us this special jury. And he immediately realized that was not appropriate, so he backed off of that a little bit. But we do see that an awful lot. And for folks who aren't experts in death penalty law, what happens is everybody's entitled to a fair jury. The defense is entitled to a fair jury. The state's entitled to a fair jury. And so to create a fair jury, jurors are asked a series of questions. Now, normally in a non-capital case, it's like, do you know a police officer? Would you be more willing or less likely or more likely to believe somebody because they're a police officer? Do you have anybody in your family who's been convicted of a crime, who's been a victim of crime, and so forth? But in death penalty cases, there's this second level of jury questioning about whether they can follow the law and follow their oath when it comes to capital punishment. So do they have views about the death penalty so that they would not be able to convict, or they would not be able to impose the death penalty? And unless they say they're willing to cast the first stone and swear to that, they cannot serve in a death penalty case. That results in a jury that is statistically much more likely to convict, and more likely to convict of more serious charges. And all the data from the Capital Jury Project showed that as many as 10% of the jurors are already convinced before they even go to trial that the defendant is guilty and should be sentenced to death. So that's for those of you out there who aren't specialists in death penalty law, you just got one of the lectures from my death penalty class.
It's all in the book. It's in
It's all,
the book. I used to teach them how to question this book. This is 280 some pages. How you qualify a jury and asking those two levels of questions, not only finding a guilt, but you hold the key to the death penalty. If you don't find them guilty of murder in the first degree in the first place, you can't get to the death penalty. So you're right. That's what I would teach right here. And so ask that question: does death qualify a jury? And you'll be surprised. You the jurors come back and they can you get a strong juror here. And statistically, maybe you found this and maybe you haven't, but the jurors want to do the right thing, and they're going to follow the leader in the courtroom. And if the district attorney is a leader in the courtroom, they're going to follow him. The defense attorney is in charge, going to follow him. And unless there's an equal push between there's an Ernie Preate and a Harold Caine in the courtroom, and that's entertainment there. That's drama. When Harold and I got in the courtroom, then we'd line it up out the hallway, down the stairs, out the building. Because those days didn't have any color TV in the courtroom, any TV at all. So, but anyway, point being, you need the prosecutor has to realize that he has a very powerful weapon when he is asking for the death penalty, because he gets to utilize those two levels of jury questions, and he can and jurors, by the time the opening statements are over, 60-70% of them made up their mind already. I mean, we're talking about the rest of the trial for 6 weeks going to be determined, trying to figure out what the other 30% are going to do. So you'll be surprised at how important you won't be, but folks, and it's what happens in a courtroom when you have those kinds of those questioning going on to educate the jury. I used to do 3 closings, Rob. My opening, okay, was 2 hours long. What I'm going to prove. Then in the middle of the case with my expert, I had a hypothetical question that went on and on for 20 or 30 minutes, assuming this was true, assuming that was true, assuming that was true. What would you say was the cause of death? Homicide. Okay. Then I'd have my closing. By that time, you've educated the juries on everything. You don't even have to have. I mean, I used to teach all that stuff. Those are the days. Now,
another thing that's really interesting, I think overlooked a lot, is jury confusion about the instructions in
yes,
cases. And the Capital Jury Project, and this number sticks with me. I will never forget it, because it's the normal body temperature of a human being, 98.6. When they interviewed 73 jurors who had actually served in Pennsylvania death penalty cases, and they asked them about the jury instructions in the case. And 98.6% of the jurors who had actually served in death penalty cases misunderstood the instructions in a way that was prejudicial to the defendant. It was stunning. And one of the big problems, I think it's probably less of a problem now than it was when we were really going at it in the 80s and 90s, is what does a life sentence mean? In Pennsylvania, more than half of the jurors believed that a life sentence was 15 years or less. And those jurors were twice as likely to vote for death than jurors who believed that it was longer than that, when in fact, it's life without parole, and it's been life without parole throughout that process. The study also showed that more than a third of the jurors who had actually voted for death said that they thought that life without parole would have been the appropriate punishment in that case. So we know that this jury misunderstanding has led people to be sentenced to death who jurors, if they understood the law and followed the law, would have sentenced to life.
Well, that was Blaistone. Too, as you
Well,
pointed out.
I think that's probably true as well. I
Yeah,
think it's probably true for
I'm
that
sure
case
they
as
didn't
well.
get. I'm sure they didn't get that in then that clear instruction that the facts and circumstances of the crime can be mitigating.
And we've had 300 death sentences that were imposed before the Pennsylvania courts began providing a life without parole instruction. And that's, to me, if I'm on a jury, if I'm on a death penalty jury, and I'm trying my best to do what's right for the case and what's right for the public, for public safety, the most important thing for me is going to be, is this guy going to be dangerous if we don't sentence him to death?
Well, are we getting ready to close here? Kathleen is giving me a wink here and a nod
Well,
that we should be asking.
no. Here's what I'm thinking.
Okay.
I'm thinking that technically the audience has already put in their time and gotten all they're going to get for the price that they paid to get in. Ha ha, which was free. Anyway, I think you guys should keep talking as long as you'd like.
Okay. There's no questions that the audience wants, so I'm fine.
Okay.
If they have, maybe they have a question that we haven't talked about. I don't know.
Can you see questions, Rod? I can't see them.
I can see the Q&A.
Thank you.
And
I know one thing we had talked about was cost.
yeah,
Ernie, when you were prosecuting, you had said that the cost was interestingly high.
Yes.
one of the criticisms that we have that we see frequently in death penalty cases is that they're not cost effective. And by that, they cost more, much more than a non-capital case. And we've already talked about they don't contribute to public safety. But what was your experience regarding the cost of death penalty cases?
Well, it's the prosecution has a somewhat unlimited budget. Maybe in my county, Lackawanna, it was a fairly big county, third class. So other counties, fifth and sixth, seventh classes. I mean, they don't have that kind of money to do a death penalty prosecution. And the DA is maybe one DA or two DAs. You take them out of the action for 3 or 4 weeks in a death penalty case. All these other cases don't get prosecuted. So the money does play a role. The county commissioners tell you, no, wait a minute now. Let's not go and get all these people. But I know that's what you're a prosecutor. You're going to fulfill your duty. You're going to have to get the experts to come in, and it's going to be costly. And the same with the defense.
Yeah.
If they're petitioning the court to have me spend this much money or that much money, but the court didn't. This is what gets me. The court can say, "I'll give you. You asked for 6. I'll give you 3." Well, judge, I can't get them for 3. Well, that's all I'm going to give you. That's not the way that system is supposed to work. You're supposed to have the same opportunity to get an expert and without regard to finances. But some of these counties don't have that kind of budget. They just don't.
And the result of that is when there are capital prosecutions, the defense is very frequently prevented from being able to develop its case properly.
That's right, exactly.
So one of two things happens. Either you spend a disproportionate amount of county money and you go through with the capital trial, or you don't spend the money up front. And then what happens? In Pennsylvania, when the lack of resources prevents the defense from presenting the case for life, what happens is that 100 of those cases have been overturned for ineffective assistance of counsel. And so, defense counsel gets blamed for it. And in many of the cases, it is inexperience and it is poor quality defense that contributes to it. But in a lot of the cases, it's because of the cost of the death penalty. And so the hidden cost is that the case comes back in the post-conviction process, and we have the 3-week evidentiary hearing in the post-conviction process that should have happened at the first place at the time of trial. And when it does happen at the time of trial, what's the result? More often than not, it's not death.
Yeah.
So, that's one of the things I found really interesting. We did another, you get me going on these studies, right? We looked at all the cases that have been overturned because of in the post-conviction process, which, for those of you who aren't lawyers, post-conviction process is the stage of appeals in which, for the first time, you present evidence and arguments that weren't available at the time of trial or weren't presented at the time of trial. And we've had 150 Pennsylvania cases that I looked at that were overturned in the post-conviction process. Now, if the death penalty were statistically arbitrary, you flip a coin and you'd get death 75 times and you get life 75 times. Well, this is beyond statistically arbitrary. You got life outcomes in all but 6 of those 150 cases, which to me tells you how cost affects the entire system, but even more significantly, how arbitrary those outcomes were, because in a fair trial, we would not have had anywhere close to that number of death sentences.
Arbitrariness again.
Yeah. So here's a question that we have. Why shouldn't the Pennsylvania Supreme Court make the determination that the death penalty can't be fairly imposed, as opposed to the U.S. Supreme Court? Should lawyers be making the case in front of the state courts?
Yes. Yes, they can. They do a proportionality review now, don't they? The Supreme Court's supposed to do a proportionality review to see if that's analyzing it county by county. I don't know what the results of that are. Do you ever see that?
Actually, that raises another one of the issues. In Pennsylvania, there's automatic review by the Pennsylvania Supreme Court, and statutorily they're required to do a review for passion, prejudice, and arbitrary factor, and they do what they call a proportionality review. And it used to be that there was a rule that because death is different, we will consider any claim that gets raised on appeal, whether or not the lawyer botched it, whether or not the lawyer missed a deadline, whether he failed to raise it when he was supposed to, whether he waived it. That disappeared, so that's gone. And then the Pennsylvania Supreme Court backed off of the passion, prejudice, and arbitrary factor review. They will still do it, but they adopted a requirement that the defense has got to show them what it is that they're supposed to be looking at in their independent review. And when it came to proportionality, they repealed the proportionality review right after David Baldus did his report that showed racial discrimination in the imposition of the death penalty in Pennsylvania, in Philadelphia. And I had the privilege of litigating some of those cases. The numbers were staggering, because the odds that you'd be sentenced to death in a Philadelphia case, and this was after a regression analysis that took into consideration more than 300 different factors, the odds that you would get sentenced to death just being charged with a capital offense were 1.5 times greater if you were black. If the case went to trial, it was 3 times greater. If it advanced to the penalty phase, when you had the case for life and the case for death being presented, the odds were 9 times greater. And when it got to the point that jurors found an aggravating circumstance and found a mitigating circumstance, and so they had to weigh them, and they had the discretion to choose whether someone should live or be sentenced to die, odds that you would be sentenced to death increased by a factor of 29 if you were black. And that's about when proportionality review disappeared.
Well, again, that I think is the question is a good one, and that is, shouldn't the Supreme Court, in its supervisory power, handed down from William Penn, be able to say, we don't think that this is being applied properly in all 67 counties. So hereby we're declaring the Pennsylvania statute unconstitutional under Pennsylvania Constitution as applied by the district attorneys and and through the court system. We just don't have any confidence in that at all. And we're a federalism state. So under the Supreme Court of the United States' determination, federalism prevails. It's up to the states. Well, that ends it seems to me, because we're not offending the United States Constitution. If under our Constitution, we say we're having a more stringent standard, and that is that we're not approving the death penalty for arbitrariness or prejudice.
And that's what the Connecticut Supreme Court did under the state constitution.
How about
and that's what the Washington State Supreme Court did under their constitution.
In any event, that's a great question, but those the warriors out there amongst listening to us. That's your job now. You take it up. You argue those kinds of issues.
Here's a practical question that we have from the audience. Governor Wolf imposed the moratorium about 10 years ago, and now it's being continued under the current administration. Governor Shapiro has asked the legislature to send him a bill that would abolish the death penalty. But assuming that doesn't happen, is there a chance that the moratorium would be lifted if a new governor comes in?
Yeah, it could be. I don't remember when I was there. Bob Casey was governor. I don't remember if the governor he just wasn't signing them.
Right.
I don't remember, but I have a suspicion that because he was pro-life, he wasn't signing death penalty warrants.
That's right. And so District Attorney Morganelli filed a lawsuit against him.
Yeah, he challenged him on it.
So John filed the lawsuit, and the Pennsylvania Supreme Court said, "Hey, you can't not sign warrants." So he signed warrants, but he privately told me, because I was then running the Death Penalty Resource Center. He privately told me, I don't want to grant a reprieve, but if I have to, I'm not going to let somebody get executed. We came down to 3 days before 2 people were scheduled to be executed, and we got courts who issued stays of execution. So it never came down to whether Governor Casey was going to follow through on that. But so we now have the automatic death warrant statute, and Governor Shapiro won't sign warrants. So there's a procedure in the law that requires the Secretary of the Department of Corrections to issue an execution date. In Pennsylvania, there have been more than 400 death warrants signed. There have been 3 executions, and most of them are death warrants that are signed before the appeals process is completed. So, that was, Bob Gracie and I talked about this all the time back in the day. There was this requirement that you have what even the governor's general counsel was calling these fake warrants that were going to take up a lot of time and court resources, but were not going to ever result in executions. But right. You put the victim's family through this false expectation that something was going to happen. I had mothers of people on death row calling me from out of state saying that they'd received letters telling them to make arrangements to pick up the body when an execution wasn't even going to happen. And I think that whole process just underscored the inhumanity of the way the death penalty was working.
Interestingly enough, you have a governor who was an attorney general who was bound to carry out the laws of the decisions of the courts. And if there was a judgment of the death penalty, he had to support that. I don't think he could have avoided that, but now he becomes governor and he's not going to sign death warrants. So the lesson the politician says, you don't have to. You don't have to. You can be articulate enough and reasoned and say, I just don't think that we have an honest system. It's an arbitrary system, and that's not what we should be using to put people to death.
Here's one of the other questions that folks have. A couple of them have asked us, and we're gonna have to close up fairly soon. But one of the questions deals with junk science and the death penalty. I represented Daniel Doherty, who was sentenced to death for an arson that the leading arson expert in the United States said wasn't arson. It was junk science, the same junk science that was used that ended up executing Cameron Todd Willingham in Texas. But there's now ballistic stuff that's been questioned. There's all sorts of forensic evidence that has become really questionable, like hair comparison. Um, what what should we be doing? First, we're being asked, what should we be doing to prevent the introduction and use of junk science in death penalty cases?
Well, you have junk science and you have junk experts too.
Yeah.
I mean, there's a lot of people that say they're an expert in something and they really aren't. Okay, and that you got to qualify to make sure that they're qualified to be an expert, and the second level is being very prominent now, being analyzed in the courts as justify this as a science that's meets the standards of expert testimony, and I think there's a lot of it around, you know, but and some of the people are trying to use it on the defense side, like identification evidence. There's so many cases where the identification is wrong. Well, you can't introduce that in the case. But on the other hand, the chemical tests, DNA tests, residue tests, fingerprint. Be careful about fingerprint because fingerprint could be junk science, right?
Yeah.
So, yeah, I mean, but who's interpreting it, and so there is a battle to be launched by a defense attorney as to the acceptance of this as a valid scientific test. You got to challenge that. If you don't know enough to challenge it, you're letting it go in, and that creates an appeal issue. You got to go back and start all over again. Money.
Or if you don't have quality lawyers for a long period of time, you end up with the junk testimony,
right?
Producing an unjust death sentence.
That's what happens.
Yeah,
that's what happens. Watch that fingerprint stuff. I'm not a big fan of fingerprints. Okay, it's a lot of it's subject to interpretation. How many comparisons do you have? 8, 10, 12? I'm not sure, but I do think the one thing that we should get out of this is that let's see if we can't get DNA testing, even if it affects 15%, as you say, of the murder cases. That's a lot of lives.
Yes,
that's a lot of lives. There's a look at it in that perspective, and so let's push for a better DNA statute. Let's push the Supreme Court to do its responsibility. Have a statute. Amend this death penalty statute. If you want Josh Shapiro governor, why don't you propose that the Supreme Court do that kind of analysis that we require to see if there's prejudice, to see if there's arbitrariness, to see if there's a lack of funding and a lack of training. You want to do something to help clear up the air on death penalty, Josh? Do it.
Well, folks, we are past time, and I want to value everybody's time. I thank you all for participating. Thank you, Ernie. This has been both a fun discussion and I think a very productive discussion. Because you are such a great lawyer, and I've got a lot of respect for you. Do you want to make a closing statement to suggest to folks? No? Okay.
I have a question. You are a proud conservative Republican.
Yeah.
What messages would you like to share with your colleagues?
Well, as I said, if you have to give a reason why you're going to be out there running for prosecutor, governor. I mean, or whatever it happens to be, where the death penalty is involved. And if you find that you can't do it, then don't run for it. No, or if you do run for it, you got to articulate why I'm not going to do it in every case. It'll be the rare case that ever gets it, that I ever bring it. And I'm going to bring it under the most exacting standards. And you can tell people that, and they'll understand it, and they'll like it.
And let's assume that I am a conservative state legislator, and there is a bill before my house to do away with the death penalty. Why should I vote to abolish the death penalty?
Well, because as it's being applied, it's arbitrary and unconstitutional. And secondly, because if you're a conservative, you're likely to be pro-life. Well, what's the reason? How do you figure out it's okay to allow for protecting a life at inception, but we go through a flawed system and it's okay to kill somebody we're not sure is innocent? Those things. But I think a fallback strategically is pass a law that requires the government or the Supreme Court to study this issue, to come up with the data. Are we just like you're finding already? How many cases? How much prejudice is there? How much money is there? All these factors that are going in. That requires a comprehensive study, and the governor and Governor Shapiro should appoint a commission to do it.
Thank
you. Are you listening?
Thank you, everybody. Thanks again to Witness to Innocence, to Amnesty International, and especially to Kathleen, who's hiding behind the camera, and Pennsylvanians Against the Death Penalty for sponsoring this webinar. And for those of you listening, I hope that it was a free webinar, but I hope you got your money's worth.
There she is. There she is, the computer genius.
Thank you, everyone, for joining us.
Thank you, Rob. Thank you, everybody. Hope you liked it.